Striving for fairness, how does Alberta's Ombudsman connect the dots? Peter Hourihan is our speaker today. He's Alberta's Ombudsman. He's the 8th Ombudsman in Alberta's history. It was started in 1967, having an Ombudsman in Alberta. First jurisdiction in North America to have such. Coming from Denmark myself, I'm very familiar with, I think the term ombudsman is actually either Swedish, Danish, or I think maybe Swedish it is. So I'm quite familiar with ombudsman. And I'm sure that job have changed many times over the years in terms of how you deal with governments. Without further ado, I'd like to invite Peter Hourihan up here and invite you to give him a warm welcome.
Check my watch. It is good afternoon, so good afternoon, everybody. Thank you for the introduction. And yes, when I came in and I heard the accent, I thought, oh, here's somebody who does know what the word ombudsman means and what it's about, and that's part of our goal is to make sure people do know that. So that's good. Thank you. I am Peter Hourihan, and I'm Alberta's Ombudsman and Public Interest Commissioner. I was appointed as the 8th Ombudsman for Alberta in October 2011. And as was mentioned in the introduction, we started, the first one was sworn in, started business on September 1st, 1967, and I see it's the same year that SACPA was came into existence. So we share the same history, I guess, in terms of length of time. Last year, in May, I was appointed as the Public Interest Commissioner to take on the other office. I'll spend the next 20 minutes, or a little more than that, talking mostly about my role as Ombudsman and how we can try and help ensure that transparency and fairness exists within the Alberta government. I'm going to also touch a little bit on my role as the Public Interest Commissioner, which is a new office that oversees and accepts whistleblower complaints from employees in the public sector. And I can get into a little bit about what employee means in context of this act. But first on for the role of the Ombudsman. There are 7 independent officers in the province of Alberta, and I represent 2 of them on the Ombudsman side as well as the Public Interest Commissioner. But they're 2 separate offices which are housed together in the same office or on the same site. But they're good to fit together because they fit hand in glove in relation to the philosophy and approach that the office takes to investigating or dealing with matters that come to our attention. In fact, before the Public Interest Whistleblower Protection Act came into being, if somebody had a complaint of that nature, in all likelihood they would have come to the Ombudsman in terms of the fairness approach. The other 5 officers, just so you know, of the independent officers of the legislature are the Auditor General, the Privacy Commissioner, the Chief Electoral Officer, the Child and Youth Advocate, and the Ethics Commissioner. As an independent officer of the Legislative Assembly of Alberta, I report direct to the Assembly, so I don't actually have a boss. I don't report to a minister, I don't report to an MLA or a committee or the Premier or the Speaker. I report generally to the Legislative Assembly. And that gives me, and should give me, the power of independent thought, which is the important piece of what an independent officer is and what they represent. When I first got the job, I thought, I came out of a long career with the Royal Canadian Mounted Police, and I thought, boy, I'm not going to have a boss. That's going to be wonderful. I can, I'll be able to make decisions, because then I said, a number of times, wouldn't it be nice not to have, people in your way when you want to do something, when you think it's a great idea to have to go through a bunch of bosses to do that. So I finally landed on the desk at the Ombudsman office, and I had that ability. And I thought it was a great idea until you start to think about it. Now, not having a boss actually comes with a significant amount of heightened responsibility, because now you don't have somebody sort of helping you check some of your sillier ideas. So you have to make sure that you're right. So it's an interesting concept, but one that I take very seriously, and I know my counterparts around the country, as well as the ones that have preceded me, take it extremely seriously in terms of how we think and the decisions and recommendations that we make. Both offices, the Ombudsman and the Public Interest Commissioner Office, act as independent parties and third parties. So we're offices of, well, on the one hand of last resort and on the other hand of assistance, but as a third party. This is an important point when it comes to the public's perception of what our office does and why we make the decisions that we make. And I'll get into detail in that in a few minutes. And if I use the word decision, Sometimes what I'm actually meaning in relation to the recommendations I make, or in relation to the recommendations I make on both offices. I don't actually have decision-making power at the end of the day. There's a lot of decisions that I come to recommendations, so just bear with me if I use the words interchangeably sometimes. It's important to begin, point out at the beginning, first and foremost, about that independence. I want to drive that point home if I can. I get challenged a lot about how independent I am and whether or not I actually have that independence. But it's an important piece of our bureaucracy and of our democracy, and the role that that office plays with the ministers, with the political parties, and all of the individual elected officials. As Ombudsman, my main role is to ensure the standards of fairness are applied when the public interacts, or many would say when the public collides with the provincial government. And I get my authority from the Ombudsman Act, which was brought in 1967 and has had some minor modifications over the years. The Office of the Ombudsman is really the option of last resort for people who have complained about a decision that was made in reference to them in the administrative portion of the government. We're complaint-driven. I don't, that hasn't changed over the last 47 years. For the most part, we look at individual complaints. We look into them as thoroughly as we can to determine if there's any issues that can be dealt with in reference to the individual that's complaining, but also in reference to some systemic or more widespread issues that might exist within that individual complaint. However, that said, I can do an investigation on what they call my own motion in the Act. So on my own initiative, I can look into more systemic issues. I could do that, I suppose, on a whim, but I wouldn't. I could do that based on an article in a newspaper or based on reports that I receive. But what we try to do is we try and look at any issues that we think might benefit from a systemic investigation. We try and do a bit of an analysis around those. How many complaints have we received that are similar? What's the status? What's the importance? What's the relevance in terms of where things are today? You know, are there media articles out there? Is there chatter about it? Those kinds of things. And we look into all of the areas before we determine whether or not we're actually going to do one. I also investigate matters at the request of a minister or of a committee. I can tell you that they have been done in Alberta. I think there's been a total of 17 committee or minister-ordered investigations over the years since 1967, but the last one was in 1995. And I'm not sure why that's sort of dropped off, but I suppose it's probably once, you know, when they're there and things are happening and people are resorting to them, people will continue to resort to them. But when they're out of mind, out of sight, they're out of mind. And I'd like to see that take on a little more prevalence in the future, and I will be inviting government to make those moves to have minister-ordered investigations. What better way to show transparency and accountability than by looking through your own department, having an independent officer come in and look through it at your own request. In relation to my investigations, I have significant powers at the front end, at the investigational stage. Significant powers that not many have. And that is, I have the power that I can order people under oath to give me information that they have and compel their testimony or their information or their witness material. I also have the power to take and seize and look at whatever I want, any document, anything. I can go in and I can march into a government department and I can collect those things. I can leave them a receipt, take copies, give back the originals and whatnot when I'm done with them. That's a significant power that certainly not many people have in our society and our democracy today. Now that said, with that great amount of power comes the flip side. When the investigations are done and I make recommendations, I don't have decision-making power at the end of the day. I only can make recommendations back to the government entity or department where the situation is at question. And the reason for that is it's a bit of a hamster wheel, if you will. I have great power because I only have the ability to have recommendations. And I have the ability to make significant recommendations because I have great powers. But if I wanted to get decision-making power, I would have to give up some of those powers on the investigational side, because then people's rights would jump into place. Not that people shouldn't be dealt with fairly, but rights and the ability for a more litigious approach to this would come into play, and we'd be back to a more legal system. And we want to keep in mind that the Ombudsman was brought in to work its way through red tape in government relatively quickly and not become part of the problem. So that's why the power and the recommendation authority rest with the office as they do. when I do make recommendations after an investigation, I have the power, within the recommendations, I do have the power of moral suasion or persuasion and publicity. Now, some people would say that that's not very significant. Other people, the media for one, would say that it's extremely significant. And you just look to how things can change in our society through publicity. Now, that said, we want to make sure that we do it properly. We have to be correct when we do it, because there's a huge amount of responsibility that comes with being public, especially in the Ombudsman Act, where a significant portion of our workload revolves around total confidentiality and indeed secrecy with a complainant who feels that they've been dealt with unfairly. We're expected to keep it confidential. So sometimes I get asked, why aren't you more public with it? And it's because we're protecting confidentiality for the individual, not for the government. That's not the issue. The issue is for the individual complainant. We do work in a collaborative focus. Our office does enjoy a widespread endorsement of the work we do, and we can achieve most benefits that Albertans deserve in terms of our moral persuasion. Make no mistake, though, I will apply the pressure if I need to. It's also noteworthy that in terms of my decisions and recommendations, I don't have any jurisdiction over ministers or the courts. Those are dealt with by the executive or the judicial arm of government. So I'm in the administrative stream, so I can look at the administration, the bureaucracy, that side of our structures. The judiciary is handled by the courts, and they look after that, so I'm not allowed to interfere in those areas. And the executive, the elected officials, are dealt with by folks like you, the electorate. And if you don't like the decisions that they make as MLAs and ministers and as government, then of course your decision to re-elect or not to re-elect is where it comes into play. We have jurisdiction over all the provincial departments. As well, we have the authority to investigate provincial agencies, boards, commissions, such as WCB, Crown corporations, such as ATB, financial, and professional associations, such as College of Physicians and Surgeons or nurses and those sorts of things. I do not have jurisdiction over Alberta Health Services, which is a common misunderstanding, except in a very small window through their Patient Concerns Office. I'm restricted in my authority to investigate complaints against Alberta Health Services about the facilities and the care and the treatment until Patient Concerns has looked at it. So if anybody has a complaint there, they have to go through Alberta Health Services, go through the Patient Concerns Office. At the end of the day, if you're not happy with the decision that Patient Concerns makes, I can go look into that decision that they made, but I can only look into the administrative fairness of what Patient Concerns did. Similarly, I don't have jurisdiction over privately contracted services, where government gets into an arrangement where private contracts come into play and take over what prior to that was government service. I have no jurisdiction there. I'd like to have jurisdiction there. And when asked by government, when asked by the Legislative Offices Committee, I state that I would like jurisdiction there. I would like to see the jurisdiction more or less follow the money. If government is making all the rules and paying all the bills, and it was government or ought to be government in terms of the similar types of functions that it's providing, then I think it should have jurisdiction underneath the Ombudsman Office. Other complaints that we may investigate could involve, and lots of them do, involve the denial of funding or support through programs such as AISH or Alberta Aids to Daily Living. Inmates at provincial correctional centres complain to our office. One example might be an inmate on segregation who's not provided telephone or shower facilities, and it can happen. After they've gone through the relevant appeals or review processes, we may be in a position to investigate a complaint from that area. One of the reasons that we investigate these areas is because there's a certain amount of expectations that Albertans have about fairness, and that's continuing to rise in a favorable fashion. Fairness is expected and fairness ought to be delivered. It wasn't all that long ago that the government decision makers could just say no. They didn't have to give reasons. They just said you would go in and apply for something. They say no, denied. You know, it seems like they had two stamps, right? No and denied, no others. And that's no longer effective. You can't do that anymore. And we'll make sure that that doesn't happen any longer, especially in an era where accountability and transparency are key. Albertans should expect all public sector institutions to clearly demonstrate what they've investigated, what their decisions are, and how and why they've made those decisions. And the more complex and complicated the government gets, the more challenging it can be for Albertans to navigate through that bureaucracy. If you just think back, in 1967, the Ombudsman was brought into Alberta to navigate through that bureaucracy because it was felt that it was getting a little bit intimidating, a little bit confusing to work your way through it. move ahead 47 years. Just think what it's like today, how complex it is with all of the changes that have come in since 1967. And that's why it's important that for people to understand that the role of our office plays. We may be in a position to help. We may not, but we may be, and that's where we encourage people to call. Our work is largely based on the legal concept of administrative fairness. There are a number of administrative fairness guidelines we measure when investigating a complaint. These guidelines have been developed over the years through the case law. This includes whether a decision maker was, for example, biased in their decision. We also look at whether a decision maker followed the correct procedure and made the decision in accordance with the legislation, or even if the person making the decision had the legal ability to do so. Pardon me. We also ask, did the complainant have a right to an appeal that was not provided? Have people been given a fair and full ability to present their case to the decision maker? Oh, thank you. Were proper reasons given to the person, the complainant, when going through the process? And was the process fair? If a review committee is making a decision and has provided the evidence it considered, has it provided the evidence it considered to the complainant when making the complaint? If we find someone was treated unfairly by a government authority, we're able to make recommendations, as I said earlier. That might be in the form of a policy change. When a policy is in conflict with legislation, we may recommend that it be realigned with the legislation. And policy is an interesting concept right now because, like, for example, I was talking to the Deputy Minister of Transportation here about a year and a half ago, and we were talking about policy changes. And the Department of Transportation has in the vicinity of 400 different policies. And of those 400 policies, most of them interact with policies from other departments, and there's 19 other departments. And when you start to look at the intermingling and the requirements to go, one small change in policy can take a significant amount of time and energy to change. So there's a couple things in there. It's important to get them changed when they need changing, but it's also important to understand the challenges that that can present. So don't make those recommendations lightly, and I don't. If we find the practice of a department or an authority is not aligned with policy, we will recommend it be aligned, and we'll track to make sure that it is. For example, if WCB sets a policy on their own accord to say that they're going to deal with a person in 30 days, but they're not doing so for 50, we'll go in there and tell them something's not working right. Live up to your own standards. So we may recommend those changes. We may look at the challenges that they have and listen to that for sure. We're all about government effectiveness and ability. We're not about infallibility, but we do expect them to be fair. I can say that too that if you're wondering, most of our recommendations are accepted and implemented. When I say most, approximately 98% of them are. When we make a recommendation, it's generally put into place. Some aren't. When they aren't, it's because there's a definite disagreement with us, and if that's the case, and I still am adamant, I will take that up to the minister. If the minister's adamant, but so am I, that they won't do anything, and I'm still adamant that I want to, then I can take it further and I can take it to the Legislative Assembly and they can debate it there. Does that happen very often? No, it hasn't happened since I've been here. I don't believe it happened for the last two ombudsmen before that, and I can't say before that. I haven't done the research on that, but it doesn't happen very often, which is good because it means that we're accepted before we get to that stage. One thing I'd like to point out, we don't advocate for a complainant. I'm not allowed to be an advocate and ought not to be. I'm about fair. I advocate for fairness. At the same time, I don't defend government. I look at it this way. I do advocate for fairness. So if I find that the person's been treated fairly, I have to deal with that. If I find they've been treated unfairly, I deal with it in that respect. And like I said, our goal is fairness, not infallibility, but a high level of fairness. And government wants it as well. So I'm there to help them put it into place. While government can make unfair decisions and treat people unfairly, not every complaint I get is valid about the government treating them unfairly. And you know, the most difficult job that our investigators have in my office is having a conversation with somebody who feels they were dealt with unfairly when they were dealt with fairly. It's a really tough conversation to have because the person does feel that they were treated unfairly, and they don't come by that in an insincere way at all. They're very sincere. But they're frustrated and they're tired and they've jumped through hoops and dealing with the complex maze of the bureaucracy, and they're at their wits' end. So it takes a lot of convincing for us to tell somebody that they've been treated fairly. Do we succeed all the time? No, not by any means. But sometimes we can. We can show them how it was done, how others were treated in the same circumstance, and that sort of thing. And hopefully we can provide some comfort and that they can get past the aggravation that they've suffered through the system that they had to deal with. The same thing goes with the same dynamics apply with the authorities I deal with. Sometimes they're pretty reluctant to listen to what I've got to say, but I work with them and encourage them to understand the change, understand that I am there to help and that I am part of the process of moving forward, not there to be a thorn in their side. And fortunately, we've had a good history in Alberta where we've been able to continue that and continue with that understanding of our office. Our investigations may result in a complaint gaining a benefit, but that's not particularly our goal. Our goal is the process and the ability that they have to work their way through the system. Hopefully, it helps the individual, but where it doesn't, we often are telling individuals, we can't do a lot for you right now. Let's say it's somebody that was treated rudely when they shouldn't be. We can go back and say, you were treated rudely and you shouldn't be. I can't really take that genie, I can't get that genie back in the bottle, but what I can do is try and assist that department in making sure that that doesn't happen again to the extent possible, that sort of thing. Subtle corrections are made continually, and that's why I often, people ask me, what's your job like? And I say, well, it's kind of like driving a big ship through the ocean. There's a lot of minor corrections along the way that help us get to the right place, and we get to the right place. Thank you. It's just unique. That said, I'm going to turn and give a few minutes of my time to the role of my job, the role of me as the Public Interest Commissioner. We began on June 1st, 2013, like I said, and our role in this job is to facilitate and investigate allegations of wrongdoing and protect public servants who disclose those wrongdoings within the public sector. I have the authority, much like the Ombudsman Act, to use any tool I need. I have the ability to speak with people, to take documents and go and enter premises and that sort of thing. The people that fall under the Act are more than just employees of the public service, of the departments of government out there. It also includes health practitioners. So doctors are included in large part. There's about 9,200 physicians registered in Alberta, and about 89% of those fall under our jurisdiction. Government's looking right now to see how the other 11 may apply in a different way or if they should, but suffice to say about 90% fall within our jurisdiction. Our large aim with the Public Interest Commissioner's Office is to try and change the culture where it needs changing to one where the government and the people in it encourage public servants to come forward and report wrongdoings in their field of work and make positive change, and not to be treated as an anti-organizational individual, but to be embraced for the positive and effective operations they can bring into the organization. We can protect whistleblowers from reprisal. That protection is limited in the sense that you can't protect something that hasn't happened, and if a reprisal occurs, we can't provide the protection until afterwards. But if someone discloses to us, they can disclose to us with confidentiality, and they can disclose to us information that would otherwise be a breach of their confidential agreement with their employer, in terms if they go to the media and that sort of thing, in certain circumstances, because telling us is not a breach of that, and then I can deal with it. So that's one protection that we can have. We do accept anonymous disclosures from employees, and just when they disclose, it has to be a wrongdoing. Now, a wrongdoing doesn't mean it was just wrong. It means it was a wrongdoing as defined in the Act. And that's a bit polarized in the sense that it has to be something serious. And it's an illegal act, so breaking the law, an act or omission that creates an imminent risk to the health and safety of individuals, a specific threat to the environment, gross mismanagement of public funds, or knowingly counseling somebody to do those kinds of things. A lot of people think that it just deals with a wrong, and it doesn't. I'm left with the Act. Should it deal with more than just wrong, and not so much way out there on the polarized side of wrongdoing? I can't answer that. What I can answer is that I can deal with the Act, and that's where I have to restrict myself. However, I can make comment. When something goes wrong in government, I can still make comment. Now, my expectation, wrong or wrongdoing, is still that it will change, and I expect government to live up to that standard. One of the challenges I have right now in the public interest disclosure area is encouraging the government departments and entities out there, public entities, to make sure that they get their policies and procedures, which they're required to have in place, to get them in place. And once they're in place, we can have a look at them and make sure that they conform to the standards of the Act. Unfortunately, I can't stand here today and say that that's happened completely. Of the 72 Government of Alberta agencies, boards and commissions, and officers of the legislature and health sector, 61 of them have provided that information to me, or 85%. We're moving along quite well in that regard. Not so good news, though. Of the 129 private schools, only 4 or 3% have done that work, and none of the 94 early childhood school private operators have done the work. So clearly there's work to be done. My expectation is public entities not only establish policies and procedures, but breathe life into them as well. It's important that this is meaningful and it's not just window dressing. There needs to be effective education and a follow-through across the public sector, and the onus is on those entities to provide that. Yes, we can provide some from my end, but the onus is on them as well. Information sessions, regular communication, not just an emailer out once every decade or so, but effective communication. You often hear, just in conclusion, with each passing year, talk about government accountability and transparency. Certainly there's a certain amount of skepticism in a number of circles in that regard. There's a skepticism about the role of government, even to independent officers like myself. There's skepticism of whether or not we can be effective. I look at the Office of the Ombudsman and our ability to be effective there, and I say that we can be, and I think we can be as a public interest commissioner as well. But if we want legislation to work, it has to come from everybody's part. That's us, that's the government, that's the employees. We want government employees to come forward, we want government to protect them, and we want government to see this as effective. In recent days, our new Premier, Jim Prentice, spoke about introducing an Accountability Act. I love to hear those words. He talks about accountability and transparency. Again, I like those words. As far as I'm concerned, when they're said, they mean they want it in place, and they want me to help them make sure it's in place. And that's part of my job. I'm going to encourage and help them be accountable and be transparent. The job of my office in both circumstances, Ombudsman and Public Interest Commissioner, is to hold government to its own words, and I will do that. And thank you, and after the lunch, I'm happy to take your questions.